Hello, everyone. My name is Hassan Aziz. I'm the principal solicitor of Dot Legal. Dot Legal is a firm with offices based in Maryland, majorly practicing in family law, criminal law, property, and civil and commercial litigation. So pretty much everything. We've got with us today Verinder Pawar, barrister. Verinder is a barrister at Lachlan Macquarie Chambers in Parramatta. Verinder specializes in criminal law. He has worked as a New South Wales police prosecutor for about 6 years and joined the bar in 2017. Verinder, thank you very much for joining us, mate.
Yep, no problem.
Okay, Verinder, just a few questions today. What we wanted to ask you is mainly about AVOs. And obviously there's two types of AVOs, one being where there is a domestic relationship called ADVOs, or Apprehended Domestic Violence Orders, and the second one's being Apprehended Personal Violence Orders, where there is no relationship. So the first question for you, Verinder, is what is the first thing a person should do if he or she is served with an AVO?
Yeah, so have a look at the paperwork and find out what type of order it is first.
Yep.
So if the police are involved, then it may be a provisional order.
Yep.
So if it says provisional order, then that usually means that it's been approved by an authorized justice by the time you get the paperwork. So when it's approved and then you receive the paperwork, then technically you've been served and the order is in force.
Yep.
So basically it's an urgent apprehended violence order, either domestic or personal. So have a look at that. That'll tell you what the conditions are.
Yeah.
So if that's in force at the moment.
Yep. With the conditions, you just mentioned the conditions. What conditions could be imposed with an AVO? What conditions could one expect?
Yep, so there's different types of them. Every single AVO has the standard conditions, which are not to assault, molest, harass, threaten, intimidate, or damage another person's property. So that's in every single order, which is called 1ABCD. Yes. Then after that, there's different types of other additional orders, which can include not to contact or approach in any way, except for a lawyer, not to contact or approach if you've consumed intoxicating liquor or drugs, not to enter a specific premises or not to go within a certain distance of a specific premises. There's also other orders in relation to firearms where somebody may be required to surrender firearms if that's a concern of the police or the applicant.
Right.
So there's all these additional orders which can be placed against a person. So
right.
You've got to look at find out exactly what's against you, right. And check firstly if it's a provisional order, which means when it's served with it, it's in force, or if it's just an application for an order. If it's an application, then it's not in force because there's no orders on foot that have been approved. What it means is just an application for this to be determined at court. When you go to court, the applying party can apply for interim orders, which means that it will be like a provisional order where the order is now in force until the matter is finally dealt with at court, either by a hearing, contested, or if the person just simply contested.
That's what I'm coming to. Like, a lot of people say, we don't want to accept these orders. What options do they have then? What if they say, no, well, you know, the allegations in the AVO are false and we don't believe in it. We think they're made up. What do they do then?
Yep. So there's pretty much two options. It's either first you defend it and you don't agree with the order at all. The court will then determine whether or not an interim order is required until the matter is determined. Yep. So you can contest it. The court will then set down a timetable for evidence. So the applicant will have to file by this date. The accused or respondent has to file by a certain date.
Yes.
And the matter gets set down for a hearing. So that's the one way of defending it, is to take it to court and test it. The other one is to consent to an AVO, but usually you can do so on a without admissions basis. Right. So what that means is that, look, as a defendant of an AVO, you just accept the order. But in terms of the grounds and the stuff that's written on the grounds of the application, like you did this or you did that, you don't admit to any of it. It's just a simple order. You can't do this at all, like those conditions.
Right.
So you can either test it or accept it on a without admissions basis. If you want to, you can accept it on a with admissions basis, but wouldn't make any sense to accept an AVO
And
admitting.
and accepting an AVO doesn't show up on the criminal record, does it?
That's correct, because an AVO is a civil order basically against somebody restricting their actions.
Yeah.
It only becomes criminal if you actually breach it, and then you get charged with the criminal offence of breach AVO.
Yeah. We'll get to that. But what about people that lose their New South Wales security licenses and work with children licenses and other licenses like that? Is that a repercussion of an AVO on you?
Yes, especially on a final basis. So if an AVO is made either after a contested hearing or you've made it by consent, then correct, working with children can be affected. But firearms, most definitely, you will lose firearms, and the period, I've got to double check what the period is, but it's a pretty substantial period if you carry firearms regularly.
Right. Verinder, with the breach of AVO, now we come to the serious stuff. What are the risks of breaching an AVO, and what can a person do, or what should a person do if he or she has breached an AVO and been called by the police and said, you know, mate, you've breached an AVO, how about you come to the police station?
Yeah. So look, first thing is first is when you get the AVO papers, make sure you understand exactly what they are and follow them. But if you're in the unfortunate circumstances of being charged, or like you said, police are ringing you up and asking you to come to the police station, obviously comply with all the police orders, you know, in terms of their investigation. Keep in mind that every person has a right to silence as well.
Yes.
But just in terms of breach of AVO, yes, it's criminal offence, carries with it imprisonment and or a fine. So you just got to be really careful about what the allegations against you are, and be careful about what you say.
And in the recent past, they've also added social media platforms for contacting the PINOP or the person in need of protection. Would you tell me something about that as well? Like, to make sure people know that they're not allowed to contact someone else through Facebook or Instagram or WhatsApp or any other such, platform.
Usually that's caught within the approach or contact in any way. So the terminology is in any way. So that includes everything in relation to social media and stuff. And those types of things it can be difficult to prove for investigators if there's no specific link or any ready ID. But say the victim knows the perpetrator for about 10 years or something, and the perpetrators use the same Facebook ID for all that period of time, even if it's in a different name, the identification will be strong. So you just need to realize that it includes all forms of contact, including social media, email, things like that.
Right. Now, this was all about defending an AVO and being on the defense side of the AVO. What if a person is actually in need of protection and they go to the police and the police does not think that it's a serious threat? What can a person do then? Can they privately?
Engage a lawyer to do a private application for an apprehended violence order. The only difference would be is that as a private lawyer, you can't apply for a provisional order, which means an urgent order right there and then, which is enforced upon service. That's the only issue. But the private lawyer can make an application, and then when it comes to the first return date, the private lawyer can then ask for an interim order, which has the effect of a provisional order where the orders are in place until determined.
And the procedure would be the same as a police-applied AVO in that you'll have to go to filing the evidence.
Yes,
timetable. And then going to a hearing. And if the other party intends to defend it, you have to prove to the court on the balance of probabilities, is it?
That's correct, yeah. Balance of probabilities. It's a lower test compared to most criminal cases of beyond reasonable doubt. But the reason why is because AVOs aren't criminal proceedings, they're civil proceedings pretty much.
Right.
So probabilities.
All right, I guess we've covered everything. Look, thank you so much, Verinder, for joining us. And I hope we have given people a bit of insight of AVOs in these tough times in this lockdown. And I hope everyone is safe, stay home. and we'll be back with another one hopefully soon.
No worries at all, Hassan. Thanks for having me.
Thanks, Marina. Thank you, mate. Thanks.